Hey, my trendies, trendsetters, and my trendy tribe. As we know, Destiny and LeBerick have been back in court. LeBerick took Destiny back to court for contempt. Destiny has now challenged it, although the judge actually did find her in contempt. There was a fine, there was possible jail time. She challenged it and says he is also in contempt. And it says it is ordered, adjudged, and decreed that the above referenced matter be and the same is hereby reset for hearing on November 22nd, 2024 at 9 a.m. in courtroom number 4 of the Madison County Courthouse before the undersigned judge. It is the responsibility of the party and or lawyer to determine if a personal conflict exists upon receipt of this order and inform the court. Failure to determine if such conflict exists will result in a denial of any motions to continue for prepaid trips of other personal issues. Counsel shall comply with the 23rd Judicial Circuit's procedure for conflicts by providing the appropriate notification of conflicts to the court administrator. Counsel are urged to familiarize themselves with the procedures so that conflicts can be resolved between judges prior to the scheduled trial date. If you would like to see what Destiny was held in contempt for, keep playing. LeBerick entered a objection to defendant Destiny Williams' counterpetition and motion to dismiss. Okay, it says, comes now the plaintiff LeBerick Williams by and through the undersigned counsel in response to the defendant's counterpetition for Rule Nisi filed in this action, respectfully requesting this court enter an order dismissing the same, stating as grounds therefore the following. So basically, LeBerick and his attorney object to Destiny trying to get this one dismissed, the other one she opens separate from this one be the one that everybody goes to, and all this other stuff. So that they're objecting to all the rigmarole outside of him already filing for contempt back in September 2023. Okay, so it says this is a contempt Rule Nisi action filed by the plaintiff on September 30th, 2023. The defendant filed an answer and counter petition for Rule Nisi in this action on May 10th, 2024. Said filing contains several defenses as well as further claims of contempt alleged to have been committed by the plaintiff. Trial in this matter is set for June 4th, 2024, less than 30 days from the date of the defendant's filing. This matter has been pending in excess of 7 months. The time for the defendant to file her answer has long passed. The time for the filing of her counterpetition has therefore also long passed. It would be fundamentally prejudicial to the plaintiff to require him to defend the new claims of contempt raised by the defendant at the 11th hour. The defendant's introduction of her counterpetition at this time would require this court's permission under Rule 13F, which has not yet been given and which the plaintiff would vehemently oppose. The Alabama Court of Civil Appeals and the Alabama Supreme Court have consistently held that it is within the trial court's discretion whether to allow an omitted counterclaim under Rule 13F. With very few exceptions, our appellate courts have generally affirmed the trial court's exercise of discretion. Whether the trial court granted or denied relief to a counterclaimant, we have usually upheld its action. Additionally, the formal answer filed by the defendant contains first mention of allegedly applicable affirmative defenses, many which would require the plaintiff to employ discovery mechanisms to discover what basis the defendant has for raising said defense, and thereafter litigating the issue to prepare to rebut at a trial. Like the defendant's counterpetition, her affirmative defenses were due with her answer long ago. The late raising of said affirmative defenses is improper and prejudicial to the plaintiff. So, summary so far, Destiny's late stall tactic. That's what the attorneys are claiming, stall tactics. This doesn't coincide with anything that would make sense for it to be proper in the court. Obviously, more time would be needed, but it's already drug on for 7 months so far. That's what's happening right now. It says further, the plaintiff, LeBerick, notes that the defendant's counterpetition for contempt / Rule Nisi was filed so late that the plaintiff would be unable to avail himself of the 30 days afforded to him to file an answer or response thereto as permitted to him under the Alabama Rules of Civil Procedure. Further, most avenues of discovery are effectively closed to him to assist in his defense of said claims due to the delay in filing said counterpetition. The plaintiff does not seek any delay of the trial of this matter. The moment of the execution of justice is arriving swiftly, and the defendant has yet again acted in a dilatory manner, seeking to avoid being held to account for her actions. Wow, okay. The plaintiff should not be prejudiced by being forced to prematurely defend claims brought on the eve of trial, nor should he again be forced to wait to have this court hold the defendant to account for her contemptuous actions simply because of her latest stall tactic. Okay. The defendant has already brought her claims via an alternative avenue in her petition for Rule Nisi and petition for modification filed in the .03 action. Dismissal of her claims in this action would not deprive her outright of an avenue for relief on these alleged acts of contempt. Further, the defendant has filed in the .03 action a petition for modification, which this court has rightly declined to consolidate with the instant action. Therefore, it is not an issue of judicial economy to litigate the defendant's claims of contempt against the plaintiff in this action, when another avenue with the same parties is also pending before this court. It was basically like she filed this duplicate. It was duplicate, but had more information. She filed that petition separately to hold him in contempt of court. And she then wanted their cases to be consolidated that he already started back in 2023. I'm just repeating for people coming in a little bit later. And so the court they denied it. They would not consolidate. They were not extending anything at that time. It says, if this court is not inclined to grant this motion outright, the plaintiff respectfully requests this court either enter an order, either setting this matter for a hearing, or in the alternative, that this court allow the plaintiff the opportunity to submit a brief of applicable Alabama case law and rules in support of this motion. Wherefore, the foregoing premises considered, the plaintiff requests this court enter an order dismissing the defendant's counterpetition for contempt. Further, this party respectfully requests any and all further and or different relief to which he may be entitled under the circumstances. Okay, so that's the first one. That was LeBeric's motion to, that was his motion to deny, her motion to dismiss. And we're going to the next document. I just have to work with StreamYard here, because it's a booger. Okay. So that was, let's see here. What was that one? Okay, that one was May 17th, 2024. This next document is also May 17th, 2024. Okay, so it says, response to plaintiff's objection to defendant's counterpetition and motion to dismiss. So to kind of unweave that web, basically, Destiny is responding to LeBeric's objection to her counterpetition and the motion to dismiss. Okay. So it says, comes now the defendant, which would be Destiny, in the above entitled cause and files this, her response to the objection to defendant's counterpetition and motion to dismiss filed on May 17th, 2024, and respectfully represents unto this court as follows. Defendant admits to the allegations contained in paragraphs 1 through 3 of plaintiff's objection to defendant's counterpetition and motion to dismiss, insofar as that defendant's counterclaim was filed on May 10th, 2024, and that the trial is set in this matter on June 4th, 2024. That plaintiff's averment that defendant has failed to file an answer in this counterpetition for several months is inaccurate, given the stay in this matter was only lifted in March 2024. And further, that this case has been stayed by order of this honorable court since October 3rd, 2023, less than 2 weeks after the original filing of the plaintiff on September 20th, 2023, and less than 1 hour after the filing of plaintiff's amended petition for contempt on September 26, 2023. The stay was put in place, which is like the court proceeding stopped, because Destiny filed for bankruptcy and they could not continue with this motion for contempt while Destiny was in bankruptcy. But LeBerick went to the bankruptcy court, filed to be basically alleviated of whatever else she was doing with the bankruptcy court. It was granted. He had to bring that ruling back to this court, and they continued with proceedings after they got that ruling from the bankruptcy court. So when she's talking about that stay of where it was on pause, that was because of her bankruptcy filing. Okay, defendant avers that plaintiff has committed several contemptuous actions since the original filing of the plaintiff's filing of a petition for contempt on September 20th, 2023. Said actions giving rise to several of the claims in defendant's answer and counterpetition for Rule Nisi, including recent unilateral changes of healthcare providers of the minor child and continued attempts to alienate the minor child. Defendant further avers that the plaintiff has acted in a manner to disrupt the defendant's attempt to defend herself in litigation through continued harassment by the plaintiff, such as swearing out an affidavit for the arrest of the defendant on, quote, new charges stemming from the same incident for which he had the defendant arrested months prior, despite those earlier charges from the same incident having already been dismissed by the court for lack of probable cause. That was the initial fraud charge that now has a new name that I'm keeping up with because, yes, the first one was dismissed and then it was brought under a different charge name. And then y'all, of course, if y'all have been on YouTube at all, you saw when it happened the second time. Further, the defendant avers that the plaintiff directed officers to arrest the defendant while she was at a doctor's appointment for the minor child of the parties. That pursuant to Rule 13 of the Alabama Rules of Civil Procedure, the claims of the defendant are compulsory counterclaims in that several claims of the defendant arise out of the same set of circumstances and occurrences as that of the claims outlined by the plaintiff, and further preventing defendant from making such counterclaims would prejudice the defendant by preventing her from being able to properly litigate her claims and answer the accusations of her accuser, the plaintiff, in the court of law. Now, the thing is that I understood is not that she couldn't have a counterclaim or a response. It was that she did it past the deadline. That's really more the issue. Then you can't argue for yourself. You just did it past the deadline. It says that given less than 30 days ran from the filing of this cause to the stay being filed, the claims made by the defendant are made to clarify the claims and defenses of the defendant and preserve the record for such, given the defendant has been without the assistance of counsel since January 9th, 2024, 2 months prior to the lifting of the stay in this matter in March 2024. And what we saw in the previous part was that Destiny had terminated her relationship with the previous attorney. Then the other attorney, the new attorney, filed their notice of appearance. But the new attorney's notice of appearance was filed before it came to light that the other attorney no longer had the attorney-client relationship with Destiny. Defendant avers that dismissing the answer and counterpetition for Rule Nisi of the defendant would further prejudice the defendant by forcing her to litigate a case in which she has not been permitted to file an answer with the appropriate defenses that are applicable to the claims of the plaintiff, as it would dismiss both the compulsory counterclaims and the answer itself of the defendant, depriving her of due process under the law. That even if plaintiff's arguments are held to be true on their face, as stated in the plaintiff's own objection to defendant's counterpetition and motion to dismiss, it is in this court's discretion whether to allow such counterclaims. With very few exceptions, our appellate courts have generally affirmed the trial court's exercise of discretion. Whether the trial court granted or denied relief to a counterclaimant, we have usually upheld this action, so they cited the same case. That further, there is no general prohibition against permitting a defendant to raise their counterclaims, especially as not counting the period in which this matter has been stayed by order of this court. This case is headed for trial after pending less than 4 months in total. That the defendant avers the allegations of the plaintiff in paragraphs 8 and 9 of plaintiff's objection to defendant's counterpetition and motion to dismiss are without merit, given that plaintiff claims this matter has been pending for, in their words, several months, yet at no point in this litigation found it necessary to employ the discovery mechanisms referenced in such pleading. That the defendant further denies the allegations in paragraph 10 of the plaintiff's objection to defendant's counterpetition and motion to dismiss, and that given the defendant's motion to continue has already been denied, the denial of plaintiff's motion to dismiss cannot in any way cause a further delay of the trial as plaintiff alleges in such paragraph. I don't understand the logic of this last paragraph, because of course it would delay if the motion to continue was denied so the trial could keep going. But they're saying that the court should listen to them to dismiss the whole thing. That's definitely a delay. That's like starting fresh, I believe. So, unless it's dismissed with prejudice. So I don't understand the logic in paragraph 10. For me, I don't understand that. Further, if the shortened time for discovery prejudices the plaintiff as alleged in their motion, such shortened time also prejudices the defendant, as defendant is under a vastly shortened time frame to issue subpoenas and discovery in this matter for preparation for trial on June 4th, 2024. That if this honorable court determines it is proper to dismiss the defendant's answer and counterpetition to rule nisi, the defendant would, in the alternative, reserve the right to raise such defenses and claims in a separate proceeding, such as to preserve her ability to protect herself under the law. Wherefore, premises considered, defendant prays that your honorable court will enter an order granting relief to the defendant by denying the objection to defendant's counterpetition and motion to dismiss, and further set the claims in the defendant's answer and counterpetition for rule nisi to be heard with trial in this matter on June 4th, 2024. In paragraph 10, they're trying to get it thrown out. The lawyer throwing ish at the wall to see what sticks. Okay, then that's what I gathered from it. Thank you. All right. Now what? Okay, we're going to the next document. Again, StreamYard limitations. So give me just a moment to open the next one. All right. Now, what is this one? Okay, I just want to show y'all this just to be fair on both sides, because I showed when the other attorney had a conflict, when Destiny's attorney had a conflict with their dates. So I'm showing you when LeBerg had a conflict with his dates. His attorney had conflict with the dates for the same trial date. So this is just to show to be fair. Okay, so it says May 20th, 2024. Dear honorable courts, I have the following cases set for trial and or hearing for the week of June 4th, 2024. And I hereby provide this notice of possible conflicts. So he has trial at 9 a.m. on June 4th a lot. There's a June 5th one. And then he said, this is the attorney for LeBerg. Additionally, I want to inform the courts that I have a medical procedure currently scheduled for Thursday, June 6, 2024. Due to this procedure and the expected medications prescribed, I will likely be unable to participate in trials or hearings for the entirety of Thursday and Friday. Okay, so there's that one. I'm going to the next one. So this is the court's order in answer to the motion that was filed. Let's see, present screen again because StreamYard sucks. Okay, there we go. So this is the May 28th, 2024 is when the court answered the motion. The order, it says motion to dismiss or in the alternative summary judgment filed by Williams Destiny is hereby other. So it's not denied, it's not granted, it is an other. Okay. And it says the defendant's counter petition is dismissed without prejudice, meaning she could bring it up at a later time. The defendant will not be prejudiced as another petition has been filed and the court denied the defendant's motion to consolidate the two cases. This matter will proceed to trial as scheduled on the pleadings in this petition, which are very limited, done this 28th day of May 2024. So her motion or her counter petition is dismissed without prejudice. Okay, and because I guess they're saying because she does have that other case that is still open, so we'll have to keep an eye on that one because she filed a separate one. So they're just dismissing her counter petition. Let me make sure I read this right. The defendant will not be prejudiced as another petition. Okay, so no summary judgment. Child, let me read this again. Motion to dismiss or in the alternative summary judgment filed by Williams Destiny is hereby other. The defendant's counter petition is dismissed without prejudice. That's what I was looking for. Okay, the counter petition, which is the direct answer to LeBerg's petition, is dismissed without prejudice. But her separate one, I can't remember if I read if they dismissed that one too or not. I know they definitely denied consolidating it, but my memory is not going to serve me in if they actually dismissed that separate one. So we're going to keep going. We're in chronological order. So we're just going in how it's actually coming up. The playlist is linked in the description box. Okay. So now we are at LeBaric and his attorney issued a subpoena. There were other subpoenas, except for the officer, I don't think I showed too many of them. So we're just looking at the ones where it's more like an office or police and all that stuff. So this one, June 3rd, 2024, a subpoena was submitted by the plaintiff, issued at the request of plaintiff, appear at trial, produce records or documents, and it was issued to the Madison County Department of Human Resources. Okay, and it's the attention to the custodian of records. And it says, okay, so then we're going to keep going because that's really what the gist of. So I was like, interesting. Custodian of records for Madison County Department of Human Resources. Okay, so let's get to the next one. All right, this one is submitted by Destiny and her attorney. This was June 3rd, 2024. This is a day before their court date, unless it was pushed up. But June 3rd, 2024, it says defendant's motion for clarification comes now the defendant, Destiny L. Payton Williams, by and through her attorney of record, Kristen D. Butler, and moves this honorable court to meet with counsel for both parties prior to the taking of testimony and presentation of evidence, clarifying certain issues pending before this court for purposes of the trial in this matter set June 4th, 2024, and as grounds therefore states as follows, that in order to properly present the defendant's case regarding the issues pending before this honorable court, the defendant is in need of clarification of what issues remain pending in this case. That at the time the plaintiff filed his amended petition, he did not readopt or reavert any of the prior requests in his original petition. Thus, plaintiff's amended petition is the only pleading pending before this honorable court. Further, that plaintiff stated in his motion to lift stay filed March 5th, 2024, paragraph 4, the real property previously at issue in this action has been sold. Several requests for relief made by the plaintiff herein are now moot due to this sale. However, the numerous additional claims of contempt and requests for relief remain active. That it is not clear what claims of the plaintiff remain pending and what claims of the plaintiff has acknowledged are mooted. In addition, several claims of relief for the plaintiff are duplicative in nature and would give the plaintiff inequitable relief, unduly prejudice the defendant, and violate the due process rights of the defendant. Further, several issues in plaintiff's amended petition for contempt are inextricably related to the defendant's counterpetition for contempt and petition to modify said issues which are pending before this court and will be heard at a different date and time. Thus, said issues should be dismissed without prejudice to allow the plaintiff to file and address the same at the time that defendant's related claims are heard. Wherefore, premises considered, defendant prays this honorable court allow arguments of counsel regarding the clarification of all issues prior to taking of any testimony on June 4th, 2024, so that both parties can present the appropriate evidence and properly defend the same, which will further serve to preserve the assets of the parties for the use and benefit of the minor child and further serve as the best use of judicial economy. So the attorney is again arguing for judicial economy. I just again want to show this was filed. Now, I don't know if their court date got moved up, but this was filed a day before their original court date. June 3rd, 2024, 4:43 p.m. is when this was filed, and they normally would have had court June 4th unless the other attorney was granted a motion to continue, I guess, because he said possible conflict, and I didn't see if the court answered that or not. But here we go on what the court answered to the motion for clarification for the attorneys to meet up to get clarification on what LeBaric and his attorney still were asking for. This is what the court said in response to that motion. It says, motion for clarification filed by Williams Destiny L is moot. Done this 4th day of June 2024. So let me just make sure. I'll go Google real fast before I make my assumption of what I thought it was. Hold Hold on. Let me just make sure. It says mootness arises when there is no longer an actual controversy between the parties to a court case, and any ruling by the court will have no actual practical impact. Okay. So then we'll go to the next document. Oops. If you came in late, we are getting to the final course order, just in case you came in later and didn't hear me say that. We're going in chronological order, but we're getting to the course final order today. Okay. So then this will be short because I'm not going to read this whole thing. I'm just going to show you that the records custodian for the Madison County HR department or Department of Human Resources, they basically filed on June 10th, 2024, asking for a protective order and compensation for producing all the records that were subpoenaed from them. So basically they're asking for either for the motion to be denied or that someone has to be on camera as they review the records and someone has to pay the costs for that. Because it says all letters, reports, case status reports, or any other memoranda noting the final status of any and all case claims against the below individuals concerning their minor child, concerning LeBerick, concerning Destiny Williams. They were asking for all that. And so they just said, we need to be compensated if you're going to go through with this, and it needs to be on video and limited access. In-camera review is required before confidential DHR records may be released by the court. Okay. So got that. That's what they asked for. That's that of the court. And then the court. Oops, don't do that. Okay, the court issued the protective order. It says this matter coming to be heard on the motion for protective order filed by non-party in Department of Human Resources, and the court being of the opinion that the same is due to be granted, it is hereby ordered, adjudged, and decreed as follows. Department of Human Resources shall submit to the court for in-camera review copies of the DHR records in its possession responding to the request by Jonathan M. Lusk, Esquire. The court shall designate which portions, if any, of said records are material and relevant to the issues in this cause and not otherwise available to the parties. Said portions shall be made available to the parties hereto, their respective counsel, and officers of the court only, and may not be disclosed to any other persons. It is further ordered that the party which required production of said records shall pay the Madison County Department of Human Resources the cost of providing a copy of same, done this 11th day of June 2024. Okay, so they basically honored what Department of Human Resources asked for. And now we get to our final document. We may do some calculations together while we're here live, but this is the final order, literally titled the final order issued by the court, and we'll go through it. Okay. So it says, final order. This matter was set for hearing pursuant to a regularly scheduled and published trial docket for the week of June 4th, 2024. At the call of the matter for trial, both the plaintiff, LeBerick Williams, appeared along with his counsel of record, Jonathan Lusk. The defendant, Destiny Williams, appeared along with her counsel of record, Kristen Butler. The matter is before the court on the plaintiff's petition for contempt. The court proceeded to hear testimony and receive exhibits into evidence. The court, having considered the pleadings, evidence, exhibits, arguments, and testimony presented or retained during the course of this trial, enters the following orders and findings. The parties to this action were divorced by this court on April 12th, 2021. I'm getting my highlighter out. Okay. April 12th, 2021, which decree of divorce incorporated a joint settlement agreement between the parties outlining and addressing their areas of agreement, child custody of their child, and disposition of the formal marital residence. Said divorce decree was modified by an entry of a modification order by this court on May 1st, 2023. Pursuant to said modification order, the parties were to share the true joint custody of the minor child. The defendant was ordered to pay certain medical expenses and to provide certain items of personal property to the plaintiff that were awarded to him in the divorce decree. The modification agreement stated that upon any further instance of contempt committed by a party and the filing of a petition before this court thereon, the parties may revive claims of contempt made in this action for final disposition in any subsequent action. Okay. It says, our Supreme Court discussed civil and criminal contempt in State v. Thomas and stated, contempts are characterized as either civil or criminal. Civil contempt seeks to compel or coerce compliance with orders of the court, while a criminal contempt is one in which the purpose of the proceeding is to impose punishment for disobedience of orders of the court. The sanction for civil contempt continues indefinitely until the contemptor performs as ordered. A critical distinction is that the sanction for criminal contempt is limited in Alabama district and circuit courts to a maximum fine of $100 and imprisonment not to exceed 5 days. 1 second. I'm looking for Nightbot. Where you at, Nightbot? Where is it? Hold on, y'all. Sorry. There we go. Okay. It says this matter was stayed for a period of time as a result of the defendant's filing for a bankruptcy petition. Since that time, the marital home has been sold. Let me give you the date of this document real fast. This was August 14th, 2024, which most of y'all already know that's when that happened. So August 14th, 2024. Okay. The court is very familiar with the parties and has had more than the usual number hearings and contact with the litigants. So they make it clear they have seen them a lot. There have been repeated difficulties in co-parenting following orders and general antagonistic behavior. There were difficulties selling the marital residence, making mortgage payments, and making the property presentable. The defendant has participated in talk shows and discussed the plaintiff despite her agreement not to do so. The defendant has been late to drop off or pick up the minor child. Sorry, I gotta highlight. Okay. The plaintiff alleges that the defendant withheld the minor child. However, it appears that the plaintiff's birthday and Thanksgiving holiday schedule conflicts, or at least it did on one occasion. The court's holiday schedule and parenting time is not perfect, and the court would expect parents to resolve these issues, but clearly the parties here are unable to do so. The court will not hold a parent in contempt for ambiguities or conflicts in the custody schedule. Okay. However, the failure of either party to respect custody schedules and arrive late to exchange the minor child shall be considered by the court in any matters addressing custody of the minor child in the future. Based upon the testimony of the parties and the exhibits introduced, it is ordered, adjudged, and decreed as follows. The defendant is found to be in willful civil and criminal contempt for her violation of the provision of the decree of divorce, which provides as follows. So again, it says she was found to be in willful civil and criminal contempt. 12C, paragraph 12C, the parties hereto do hereby covenant each with the other the following: that each shall refrain from any and all words, conduct, deeds, and activities which are intended or calculated to interfere with, abuse, embarrass, or intimidate the other. That each will respect the privacy of the other from and after the date hereof. And again, just so you know, this paragraph starts off with the defendant is found to be in willful civil and criminal contempt, defendant being Destiny. Okay. It says, the court finds that the defendant willfully and contemptuously failed to pay her share of the minor child's medical bills as required for 3 separate visits. The court finds that the defendant willfully and contemptuously failed to pay her share of the HOA yearly fees on 3 separate occasions as required by the decree of divorce. The court finds that the defendant willfully and contemptuously interfered with attempts to sell the marital residence, including removing the for sale signs. The court finds that the defendant willfully and contemptuously failed to pay $5,000 in attorney's fees as required by the modification order entered by this court on May 1st, 2023. The court finds that the defendant, Destiny Williams, is guilty of 9 separate acts of criminal contempt. Destiny Williams is sentenced to 5 days incarceration in the Madison County Main Detention Center for each said 9 acts of criminal contempt. So that is 9 acts times 5 days per act. So that's where it gets to the 45 days. Is to run consecutively for a total sentence of 45 days, suspended for a period of 2 years on the express condition that the defendant complies fully, completely, and faithfully with the orders of this court in the future, including the orders contained herein. So she has to stay on her P's and Q's for 2 years. Am I right, Shan? She has to follow everything the court is ordering in this order and in whatever previous order is relevant, or she has 45 consecutive days to spend in jail. That's what I'm reading so far. The court did not impose sanctions, including incarceration, for numerous other times the defendant failed to comply with this court's order in hopes that the defendant will change her behavior such that such actions do not need to be addressed in the future. The defendant shall be responsible for and pay the sum of $12,779.13 for the attorney's fees incurred by the plaintiff for the services of his attorney in this matter. The defendant shall pay said sum to the plaintiff within 30 days of this order. This award constitutes a judgment in favor of the plaintiff against the defendant, for which execution may issue pursuant to Rule 62 to the Alabama Rules of Civil Procedure. Okay, Shan says, yep, she has to follow all orders handed down in this case, or she's going to be sat down. Thank you, Shan. Thank you. Put it in our layman's terms. I appreciate you. Thank you. Okay. It goes on to say, the defendant shall pay the sum of $1,170.77 to the plaintiff for her share of unpaid medical bills for Valley ENT and Dr. Maples as contained in Plaintiff's Exhibit number 27. The defendant shall pay said sum to the plaintiff within 30 days of this order. This award constitutes a judgment in favor of the plaintiff against the defendant, for which execution may issue pursuant to Rule 62 to the Alabama Rules of Civil Procedure. The defendant shall pay the plaintiff the sum of $639.83 for her share of the homeowner association fees and assessments. The defendant shall pay said sum to the plaintiff within 30 days of this order. The defendant shall be responsible for the defendant shall be responsible for and pay the sum of $4,093.64 for the unpaid mortgage and escrow fees since September 2022. The defendant shall pay said sum to the plaintiff within 30 days of this order. All other relief requested is hereby denied. All provisions of the prior decree and modification not herein above modified shall remain unchanged. Costs are taxed as paid, done this 13th day of August 2024. Okay, so we went to our calendar, or I went to my calendar. I'm bringing it up. And obviously, we know it's been 30 days. So it's not that I feel like I'm doing something special right now. I just want to, what I want to do is remove that. Okay. So she has 30 days. With court, I feel like court, well, it won't be September 14th. This was done August. Well, let's put it to you this way. Let's say this. Let's do some government calculations real fast. Okay. So from August 14th, 2024, with 30 days, the date would be September 13th, 2024, which would be today. But there was at least one holiday, Labor Day, which would push her up to technically possibly it being September 14th. But September 14th is a weekend. So then that means she might have until Monday legally. I don't know. That's between her and her attorney. But 30 actual days from August. Oh, you know what? Sorry. That was issued August 13th. So that's still wrong. August 13th would have been September 12th. My bad. 30 days from August 13th would have been September 12th because August has 31 days. So that's why it's 1 day less than the 13th. But since there was at least one holiday, which would have been Labor Day, she might have had until today. Right. There's 31 days in August. So she had 30 days from August 13th, which pushes it to September 12th would have been her deadline because there's 31 days in August. So that's why it's not September 13th. It would have been September 12th. But again, there was a Labor Day holiday. So maybe she has until today, but we're close. Are we not? I feel like we're close either way. So that's that. And then, of course, the actual calculations, we saw them split out for us. And because I feel like there's some of us that just want to add it up together. I feel like there are. So we'll do it. We'll add it up together. So hold on 1 second. Oh, let me on the share. All right. So for those of you that like that part, here we go with our calculations. Let's see here. So if I'm adding this up right, and we'll see, we will see. The first one where it mentioned the dollar amount was the first time she was supposed to pay the $5,000 in the first set of attorney's fees. Hold on. I'll make it bigger too. 1 second. And what do we want to do? Sorry, I don't necessarily always have to make this. You know, I'll just do this. There we go. That should be good, right? Yeah. Okay. So we had the $5,000 in attorney's fees. It's not going to be in PACER for this one. It's not federal SC. And yes, I have. Well, here's the thing. There's nothing else to check right now, SC, because if your deadline is either yesterday or today, you actually have time to do what you're supposed to do. Then someone may file later saying you did or did not satisfy what you were supposed to do. And also there's some of it, like the money wise, that's due now. Her how she acts, there's 2 years she has to act right. 2 years she has to act right. Or they could give her the 45 days in jail, the 5 days consecutive for the 9 acts. Okay. Chi said, come through with the spreadsheet. So that and thank you, Lady Robin Bird, for the super sticker. I appreciate you. Come on, we gotta pop this trunk. We going.
All right, we going. What a money reside. What a money reside. What a money reside. What a money reside.
So just to land on let me say where I'm at with it is I believe there was only one major holiday between August 13th to September 12th. So therefore it will push her to today, September 13th, which will be 31 days instead of just the 30 days, going off how the government usually goes. So her due date will be today for the monetary part, in my opinion. Of course, I will keep an eye out for at request for more time or whatever is said in this case, because it's technically not closed because there could be motions that are filed. So definitely we'll still keep up with it. But now we have gotten to where we got to the jail time of 45 days, suspended for 2 years if she acts right, and the $19,000. So we're about to add up to the $19,000 right now. But thank you so much for the super sticker. I don't think we can record it because it's already live on YouTube, Kay, but I'm pretty sure the content creators will be reacting to it soon because it is another YouTube channel. So you don't have to really record it because it's on YouTube, but I know that people will be reacting to it, giving their thoughts and stuff soon, but it was still going on. So they might still be getting their notes and thoughts together. But yeah, I'm sure it's coming. The court does give business days for payments, or does not, does or does not, Shan. The court does give business days for payments unless agreed upon because the computer is always accepting payments. Gotcha. So you're saying they do not, the court doesn't do business days? Got you. So they do calendar days. She said the court does calendar days when it comes to payment. So there's that. So it would have been due yesterday if you go by calendar days and no holidays. I hope so too, Auntie Natty. Okay, so let's get back to our math. All right, so we did the $5,000 for the first set of attorney's fees. Now we're at There's the incarceration. Now we're going to, and we're doing it down to the cent. So 12,770. Oh, type in the box. $12,779.13. And this is for his new set of attorney's fees for this contempt filing that started in September 2023. Then we have $1,170.77 for the unpaid medical bills for at least 3 occasions, I think it said. I don't know, but it just says unpaid medical bills. I'll just say that because that's what I'm reading right now. Then you have the $639.83. We need here for High T's calculator sounds that she made. $639.83 for the HOA fees and assessments. So there's HOA fees. All right. And then that's her share of the HOA fees. Then it says $4,093.64 for the unpaid mortgage and escrow fees. Since September 2022, and it said all other relief is denied. So that gives us, oh, that's higher. So I might have added something twice, but I told y'all what I just listed, and that is $23,683.37. I kept saying 19K. Maybe I undershot what I was hearing in the YouTube streets, but that gave me $23,683.37. Let me know if y'all are doing y'all's math differently, because I just want to know. That was not listed as C, and that is not what she's charged with having to pay back. She has to pay back attorney's fees. So that's not itemized from what I see as C. Francois said, "Woo, child, Destiny time is running out, girl." Hey, your favorite Libra. Y'all, please support me on Legal at Some Point for actual legal topics. So you have to kind of enjoy that if you want to be over there. So I definitely don't expect everyone to flock over there. But if you do like legal stuff, please go to Legal at Some Point. That's my additional channel that I started. 10K giveaway celebration is coming next weekend, and I'm trying to get us. We're gonna do a live sketch of a set of lips to celebrate the 10K. So all the trendy members will get their next. I know it's been a long time coming, but their next free piece of art that I draw. Glow said, "What, friends?" Okay. So yeah, and I guess I'm gonna have to give this disclaimer, depending on who comes in the middle of it. They both were supposed to follow that agreement. He's not supposed to speak poorly on her. She's not supposed to speak poorly on him. She did anyway. And then you see the actual dollar amount of why she owed what she owed. If you look at the previous parts, again, they reference the decree. They reference the agreement. They reference it by paragraph. This is what they signed and agreed to. This is what she owes at this time. Her 30 days are up. This is where we're at.